I'm really delighted to see so many folks here. You know, one of the joys of coming back to campus this year has been the return of our in-person events. And, you know, we've been choosy about what we do, but I cannot think of a better event to gather folks, to celebrate, and to welcome you to the Edward Ross Lecture in Litigation. I'm really, really, really happy to see so many colleagues and friends. I want to extend a very warm welcome to Helene, Edward Ross's wife, and to all the Ross family. I'm so glad that you are able to join us here. You know, this event really stands out for me to embody something that's that's core to Temple Law's mission, and that is public-facing social justice advocacy. We are known for our trial advocacy program, but it is at the core of who we are as an institution and has long been, and I cannot think of a better way to celebrate our mission than to celebrate the life of Ed Ross, who was a tireless advocate, who touched so many people, and we are just delighted that we get to be a small part of carrying his legacy forward. And that's important to us, and we thank you. We thank you for trusting us with that honor. So thank you. I also just want to mention that, you know, Ed, who lived by the ideals of integrity and passion, excellence to everything that he touched and did, those ideals are embodied in our speaker today. I am thrilled to welcome Christina here. Jules is going to give you an introduction, but Christina Swarns of the Innocence Project has a phenomenal leader with a phenomenal vision of tomorrow, and I think that Ed would be very proud. So thank you, Christina, for joining us. We're delighted to welcome you here. And just one more quick note. This is a very special week for us as well because this is the week that Eddie Olbaum passed 9 years ago. And I just want to say that we miss Eddie, but he would be so thrilled with this event. He would be so thrilled that this lecture continues to happen, and he would be thrilled with what we've accomplished in trial advocacy. So with that, I have to introduce the person who has carried forward that legacy, expanded upon it, Jules Epstein, Professor Epstein, who's the director of our trial advocacy program. Jules.
I'm glad we talked about Eddie. Those of you who knew him, we never stopped talking about Eddie. But I want to start today by talking about a different Eddie. I don't know if he was ever called Eddie. He was, good. That's good. So that's such a good segue. So, you know, I've gotten to give this talk every year. And that's a delight to me. But what's really special is that I get it to tell it to a new audience every year. Some returners, but some new people. And so I think about what lawyers do, and we tell stories. And when I say we tell stories, hopefully they're not fabrications or fiction, but we use stories to persuade, to inform, maybe to make us all better. So I want to start out with a little bit of the story of Ed Ross. You heard a little bit about it. I'm thrilled. I learned a new part of his story today. Ed Ross was a tireless fighter for those who were victimized, particularly, although not exclusively, victims of sexual abuse. Not exclusively, but particularly victims of sexual abuse by people in power, sadly, often in the Catholic Church. And I was really blown away when I prepared remarks for a year or two ago to learn that he was such a damned creative lawyer. He was the first one to use the RICO statute, right? Racketeering and corrupt organizations. I hope I'm not going to get the lightning bolt coming down at me now. To go against the Catholic Church. I mean, that's deep, right? But I learned something else today, just when we were talking beforehand. He didn't limit himself to Philadelphia or the continental United States. He went above the Arctic Circle to represent victims of abuse, even there with the Inuits. So a remarkable person and a story worth retelling. And that brings me to today's story. And how do I tell the story of Christina Swarns? So I think there are two ways. One is the easy way, all right? I can just read her CV, although we might be here longer than we're permitted. President and attorney in charge of the Office of the Appellate Defender in New York, at the NAACP Legal Defense and Education Fund, where she served as litigation director and criminal justice project director. A fond place in my heart. Christina was here in Philadelphia as what we call the CHU, the Capital Habeas Unit, and litigated capital cases and fought for those perhaps the most despised, those on death row. Began her career at New York Legal Aid, and now, of course, is the director at the Innocence Project. And I thought it kind of nice to read something that two pretty good guys, Barry Scheck and Peter Neufeld, wrote about her. When we founded the Innocence Project nearly 30 years ago, we imagined a dynamic organization that would be sufficiently nimble to evolve over time. The Innocence Project has proven its ability to broaden the scope of its reform agenda, and Christina Swarns is exactly the right leader to take this history and move it forward. That's pretty glowing. So let me complete the story the other way I want to tell the story. Every lawyer helps someone at some time in their career. But there are some lawyers who help someone every minute of every day in every aspect of their career. That's the kind of lawyer Ed Ross was, to what I've been told. That's the kind of lawyer we're about to hear from. Will you please join me in welcoming our speaker, Christina Swarns.
Thank you so much, Jules. I listened to these introductions and the stories of my career, often, always with wonder, because it is remarkable even for me to hear. Every time I come, first I just want to thank the Dean and Jules for inviting me, and I want to thank the Ross family, who I just met, who, I've learned a great, extraordinary commitment to social justice and to criminal and appellate defense. And so it's a privilege and an honor to have met all of you, and I'm proud to be here speaking at this lecture. But every time I come to a law school, I always feel like it's important to acknowledge, right, remembering coming to lectures just like this one. I went to Penn, just down the block, sitting in rooms like this and listening to fancy speakers with extraordinary bios and trying to envision, right, my own future in the law. And I want to start by acknowledging the fact that when I was sitting in the room and I was a law student at Penn, I had no idea what I was going to do with my career, none whatsoever. I did not grow up with lawyers in my family. When I arrived at Penn Law School in 1990, true story, I did not know what the law review was. I did not understand why anyone would go to a judicial clerkship. I was like, well, why would you just, you're just going to go practice. Why would you delay practicing? I was profoundly introverted as a kid, and so I struggled with public speaking for many, many years. And I always think it's important for me to share that story because I know that there are so many law students who will listen to this talk who already know exactly what they're going to do, right? They have their path laid out in front of them, and they have, sort of created a series of internships and steps that are going to take them, along the way in their chosen career. Those are the students I know I hire all the time at the Innocence Project. I know those students. But I also want to inspire the students like me who have not quite made it there yet. I want those students to understand that even if they feel like they're lagging behind their peers, at the end of the day, they can wind up at a podium like this one or even in the United States Supreme Court one day. I want to encourage the students who are still trying to find their way that to remember always that the path of least resistance will always beckon, but you have to know that you'll be happier and more successful if you follow your heart, like Mr. Ross did, and do what you love, even if it means taking the road that is less traveled. So with that said, I just want to acknowledge also what an extraordinary year it is for the students to be in law school, right? Issues of race and justice are once again roiling our country with debates about critical race theory, affirmative action, voting rights, dominating the news cycle, right? Videos of police killings of Black people going viral every few years. When I was in my first year of law school, Rodney King was brutally beaten by 4 Los Angeles police officers on March 3rd of 1991. In my second year of law school, those officers were acquitted by a jury, and as you all know, Los Angeles and cities across the country burned in response to the blatant devaluation of Black lives reflected by that verdict. It was 24 years later that I would stand in the well of the United States Supreme Court and argue a case that asked the court to decide, and I'm quoting the question presented, whether and to what extent the criminal justice system tolerates racial bias and discrimination. I spent the years between Rodney King and Dwayne Buck's case, that was a Supreme Court case, and beyond, sort of examining the interplay between history, race, and justice as it applies to the criminal legal system. And I concluded 2 things. First, William Faulkner was right when he said that the past is never dead, it's not even past. And second, that Amanda Gorman was right when she said, there is always light, if only we are brave enough to see it, if only we are brave enough to be it. So today I'm going to talk about 3 cases that I think show a little bit about the ways in which our country's history of race and race troubles impact the contemporary functioning of the criminal legal system. 2 of those cases are not innocence cases, and the last is. And I'm going to tell you about some extraordinary individuals who stepped forward to interrupt sort of the legacy of racism in this country to ensure that justice was done. So, as Jules said, I spent 15 years at the NAACP Legal Defense Fund. I'm from New York. I was raised in Staten Island, and I spent my entire life in the Northeast, so it was Staten Island to DC to Philly and back to New York. So when I went to LD, I had never been in the Deep South. But one of the first cases I was assigned to when I was a lawyer at LDF was a capital case in Arkansas, in Pine Bluff, Arkansas, which is about an hour outside of Little Rock. Our client was convicted of an ATM robbery murder. Our client and his co-defendant were Black. The man who was killed was white. And you know what our job was. It was to identify constitutional grounds upon which to challenge the conviction and the death sentence. So we had to go and we had to reinvestigate the case to see if there were any holes in the prosecution's theory. We had to determine whether the defense had done everything it could do. And we also had to conduct a comprehensive mitigation investigation to put our client's life story into perspective and offer a compelling case for a life sentence instead of a death sentence. But we also understood that every single capital case is as much about the person on trial as it is about the place that the trial takes place. So we knew we had to learn as much as we could about Pine Bluff, Arkansas. So the first thing we did when we arrived into town was to try to identify local lawyers that could talk to us just about what is it like here, what is the criminal, how do things work here in Pine Bluff in terms of the criminal legal system. I can tell you that one of those lawyers we identified because he had a billboard just on the highway, like it wasn't a sophisticated operation. You know, we came into town and we just had to find people who were willing to sit down with us. So we went to the billboard guy, we went to the people who we knew had previously practiced criminal law. We just went to anyone who really, frankly, would take a visit from a handful of lawyers from the NAACP Legal Defense Fund. So we asked about the judges, right? We said, tell us about the judges. We asked about the prosecutors. They tell us about how the prosecutors are. We asked about jury selection. You know, we asked the normal things. But given the population of Pine Bluff, which had a healthy percentage of Black people, majority Black in the city, we had some questions about the composition of the jury in our client's case. And through those conversations with the lawyers that had, been practicing in Pine Bluff for a long time, we learned a lot about a lot of things. But one of the things that emerged pretty quickly was that the lawyers kept saying to us that Black people were afraid to go to the courthouse. So that was weird. And the first time we heard them say it, I sort of assumed it was what happens everywhere, right? I practiced in Philly. People don't want to serve on juries, right? It's the usual. So that's sort of how I interpreted it the first time I heard it. And so we started to ask, because we kept hearing it. And they told us, no, you're not understanding what we're saying. It's not just that people don't want to be on a jury. It's they don't want to go to the courthouse for a marriage license. It's that they don't want to go to the courthouse for any reason. It's something different. It's not just about serving on a jury. So we were confused. We were focusing everyone's attention at this time on the year of 1993, which, as it happened, was the year that I graduated from law school. So I really, truly could not understand, right, having just come out of the hallowed halls of Penn Law School, why anyone would be afraid to go into any courthouse anywhere, with all the hubris of the North and my privilege. I had no idea. So this question, right, we had to resolve it, though, because it really did have implications for the case that we were litigating. And so it sent us sort of on a deep dive into the history of Pine Bluff, Arkansas. And what we uncovered was all about sort of the legal roots, right, of racial inequality in this country. It turns out the first thing we found was a footnote in a book by a historian at Columbia University, Eric Foner, who many of you know is the nation's foremost expert on slavery and Reconstruction in this country. The footnote reads as follows. It said that in 1866, 24 men, women, and children were lynched in one night in Pine Bluff, Arkansas. So that was pretty breathtaking, right? 24 people in one night, and children, right? It was horrifying. So this sort of, kept us going in terms of our quest to understand what was happening. We then found, not surprisingly, newspaper articles documenting flight out of Pine Bluff, right? You see newspapers saying that Black people were all fleeing north from Pine Bluff in the wake of this episode of extraordinary terror. So we kept going and kept digging and trying to understand what was happening, and we learned that there were an additional 8, at least, additional lynchings in Jefferson County between 1878 and 1926. I say at least because, as you might understand, right, they're not well documented, right, facts. You find what you can find in newspapers, but many of those lynchings go unrecorded. And so the ones that we could find were the 8. And so we dug into sort of each of the 8, and what we learned was 2 of those lynchings took place in one night in 1892. An article in the New York Times reported that those 2 men were lynched on a lamppost in front of the Pine Bluff County Courthouse. And suddenly, this fear by the Black community of going to the courthouse became a lot more clear. The composition of our client's jury, right, and the question of whether that jury was drawn from a fair cross-section of the community, as the Constitution requires, also became a source of real, live concern. But that's not all we learned. We also learned that at the time of our client's trial, Pine Bluff had something of a segregated court system, which of course is strange. But this is what happened. In 1991, the Legal Defense Fund, long before I got there, brought a lawsuit challenging the way in which judges were elected in Arkansas. Specifically, the LDF said that Arkansas had an at-large voting system, and that at-large voting system prevented communities of color from electing candidates of choice, and that violated the Voting Rights Act. LDF won the case. Arkansas transitioned from the at-large system to a district-based voting system for judges. Fine. So that case is called Hunt versus Arkansas. In Pine Bluff, that decision was interpreted to mean that there had to be a Hunt seat. That's the Hunt case, right? A Hunt seat for a Black judge. So around the same time, the county also decided they needed to create a better system for public defense, And so they contracted with two local law firms to serve as the public defender, right, for the county. Sort of one was conflict counsel for the other. One firm was all white, and the other firm was all black. The black firm was assigned to the courtroom of the black Hunt judge. The white firm was assigned to the courtroom of the white judge. And then we did an analysis of the jury pools. And our research showed that the juries in the courtroom with the black judge and the black public defender were far more diverse than the juries with the white public defender and the white judge. So Pine Bluff essentially had created a separate and unequal court system. As it turns out, our client's co-defendant who was prosecuted as the shooter in this case, was assigned to the black public defender and the black judge. He was given a plea bargain that allowed him to avoid the death penalty. Our client, who was not the shooter, was assigned to the white public defender and the white judge. He, of course, was condemned to death after a trial in which black people were excluded from service on his jury. So at the time of my client's trial, the history of racial terror was driving people away from the courthouse, and there was a segregated court system. And I wish that was all, but it's not. We then, in our course of meetings, met with the first black prosecutor in Jefferson County, Arkansas. So same questions, right? Tell us what it's like, tell us about the way things work, talk to us about, your experience in the prosecuting attorney's office. He ultimately went on to testify in the evidentiary hearing in this case, and I'm going to tell you what he testified to, but before I do that, I just need you to understand this was a standard state post-conviction evidentiary hearing on a capital case. The state was represented by two assistant attorneys general, and we offered, and the gentleman, the first black prosecutor in Jefferson County, offered the following testimony without objection. This is what he said. So we asked him about jury selection. Tell us about jury selection. What was it like? And I'm quoting from the transcript. Black jurors had a fear of serving. They had a fear of if you made a decision that displeased the white community or the white power structure, that some type of retribution. If you had a jury with 11 whites and 1 black and an elderly black, that one black person was not going to buck those 11 white people. And that was pretty much true. There were people who, again, remember coming out of segregation, you had laws on the books that said a black person couldn't serve on a jury, couldn't testify in court, depending on how far back you want to go. There was no history in this county, in most counties, of black people having served as jurors. In general, and I'm going back now, and now, of course, my little app is frozen. I still have to go to paper. And I'm going back now to the 70s. The courthouse was a bad place for a black man to be. So people didn't want to come to the courthouse, didn't want any contact with law enforcement officers. They were fearful of, prosecutors. Again, we took this testimony without a single objection by the two assistant attorneys general in representing the state. That testimony was followed by other testimony from another attorney who offered similar experiences. So I start that story just as a reminder, as much for me as anyone else, right, that it's so tempting to view this history, right, the history of our country as so remote from where we are now and so remote from the way the criminal legal system functions today. But at least this case for me made clear, right, that history of inequality, the history of racial terror in this country really does continue to impact the way the criminal legal system functions today. So once we got through that case, I really started thinking about history, right, and the impact of history and how we think of history in the court system, right? What do we do with that kind of history when right, this is impacting literally the way my client's case was tried? In 1903, W.E.B. Du Bois observed, right, the problem of the 20th century is the problem of the color line, right? His statement was both prescient and incomplete because, of course, racism, racial discrimination has roiled our country, since its inception. And those challenges have persisted well into the 21st century. And as it turns out, time and again, the courts have been struggling, right, with how to ensure equity and fairness, given both that history and the contemporary manifestations of it. And that the Supreme Court has examined and sort of wrestled with that question on more than one occasion. In 1987, the Supreme Court said, and I'll quote them, "Unless historical evidence is reasonably contemporaneous with the challenged decision, it has little probative value. Although the history of racial discrimination in this country is undeniable, we cannot accept official actions taken long ago as evidence of current intent." That was McCleskey versus Kemp, right? A decision in a case that the NAACP brought to the court challenging the administration of the death penalty in Georgia. LDF had urged the court to declare the death penalty unconstitutional given both the extensive history of racial bias in the court system in Georgia and the fact that there was significant statistical disparities in the administration of the death penalty, with black people who were convicted of murdering white people, the most likely combination of race of defendant, race of victim, combination to receive the death penalty. So under McCleskey versus Kemp's analysis, right, the historical evidence of racism, right, of that I uncovered in Pine Bluff, right, wasn't contemporaneous to the issues, right, the issues in our case. So under that theory, it had little probative value. But it doesn't really match so much the experience that I had. So we kept looking, kept sort of going on. And of course, in 2013, the Supreme Court struck down a provision of the Voting Rights Act in a decision called Shelby County versus Holder. In that decision, authored by Chief Justice Roberts, they sort of reached a similar decision. Justice Roberts wrote, "History did not end in 1965. By the time the Voting Rights Act was reauthorized in 2006, there had been 40 more years of it. And yet the coverage formula that Congress reauthorized in 2006 ignored these developments, keeping the focus on decades-old problems rather than data reflecting current needs." Justice Ginsburg, as you may know, dissented, and she disagreed with the court on this point. And she wrote, "Voting discrimination has evolved into subtler, second-generation barriers. And consideration of the long history of voting discrimination still in living memory was altogether appropriate." She says the court criticizes Congress for failing to recognize that history did not end in 1965, but the court ignores that what's past is prologue, and those who cannot remember the past are condemned to repeat it. And as you know, right, that sounds far more like my experience in Pine Bluff. So after the Pine Bluff case and after sort of thinking about history or just dealing with history, sort of, living with these cases, I spent, after about 10 years at the Legal Defense Fund, I wound up representing a gentleman by the name of Dwayne Buck, and that's the case I argued in the United States Supreme Court. Mr. Buck was prosecuted for the murder of 2 people in Houston, Texas. His case was not a whodunit. It was not an Innocence Project case. He was arrested at the scene. And both the prosecution and the defense understood that the main question in this case was going to be the sentence. Was Mr. Buck going to be condemned to death, or was he going to get a life sentence? In Texas, where this case took place, a jury finding of future dangerousness is a prerequisite for a death sentence. So everyone in this trial is laser focused on the question of, can the prosecution prove future dangerousness? So Mr. Buck's trial counsel does the right thing. They hire an expert before trial. They say, "I want you to evaluate the facts of the case. I want you to meet with Mr. Buck, look at his criminal history, figure out and make an assessment. Do you think that is he likely to commit criminal acts of violence in the future?" So they do that. They have this expert go in and he does this evaluation. And then before the start of trial, before jury selection, the expert provides counsel with a report. And the report says, and I sort of will quote, "Race, period, black, period, more likely to be dangerous in the future. Black people are overrepresented in the criminal justice system." So before the start of trial, right, counsel has in their hand, right, this report saying, by their own expert, right, saying that because of his race, because of this immutable characteristic of his race, Mr. Buck is likely to be dangerous in the future, and so that is the prerequisite that is necessary for a death sentence. So counsel had a lot of choices at that moment at which they received the report. right? They could have, if they really, really loved this expert, notwithstanding the testimony, they could have, said, listen, hey, good, just a little thing we just want to flag for you, that's wrong. They're going to need you to take that out and redo your evaluation without it, right? They could have said, turns out, hey, listen, that's unconstitutional, right? You can't actually attach, right, a death sentence to race. There were a lot of things that counsel could have done and should have done. They could have, of course, just gotten rid of the expert completely. But they didn't do any of those things. And instead, counsel just called this expert to the stand and said, let's walk through your report. And that's exactly what counsel did. That's what the expert did. So he, on direct examination, at the penalty phase of Mr. Buck's capital trial, the expert says, so sad, whew, Black people just happen to be more dangerous. They're inherently dangerous. So as it turns out, this was a case where the prosecution, who bears the burden of proof on this factor, didn't have a lot of evidence to support the finding of future dangerousness. As you might imagine, usually the prosecutor relies on the criminal history, right, to prior acts of violence, prior, out-of-court acts of violence, and there just wasn't a lot of that in Mr. Buck's case. So the prosecutor, right, having seen the report, received the report, and hearing this on direct examination, this was not lost on her, the importance of this, right, in the context of this case. And so, of course, on cross-examination, she says, hey, one more time for the people in the cheap seats, right? You just said that because Mr. Buck is Black, he is more likely to be dangerous in the future, right? Expert says, yep. And then, of course, she stands up in closing and she says, jury, you can rely on the findings of the defense expert to make the prerequisite finding and sentence Mr. Buck to death. And that's exactly what the jury did. So Mr. Buck winds up sentenced to death because of his race, and he spent 21 years on death row before the Supreme Court vacated his death sentence. So, for me, this case always stands as a profoundly disturbing reminder of the banality of racism, right, in the criminal court system, and especially the capital punishment system. Because, this is 1997 when this trial took place, right? An entire courtroom of people, right? 2 defense lawyers, 2 prosecutors, a judge, a law clerk or 2, all sat by, right, as this testimony was presented and no one said a word. And the second reason is because in the 21 years between that death sentence was imposed and the Supreme Court's decision, every single court that heard Mr. Buck's case rejected his appeals. We lost in every single court that we took this case to before the United States Supreme Court. Every single one was prepared to see him go to his death because of his race. So needless to say, given my experience in Pine Bluff, I also, looked at the history of race in Harris County, that was Houston, Texas. And I can do this every day, right, in all of the cases, because this is the history of our country. But what we found, was cases showing extensive exclusion of Black people from juries. We found that Klan candidates carried the slate at the turn of the century. We found jurors complaining about art in the jury room depicting images of slavery. That was in the 1990s. We found that the elected prosecutors had racist jokes on his computer. We found that Black prosecutors complained about the culture of the office. And of course, we found an unbroken history of racial disproportionality in the administration of the death penalty in Houston, dating back to the 1800s. So it's impossible, for me to divorce the ease with which the courts accepted this explicitly racist testimony from that history. That said, in 2017, Chief Justice Roberts, writing for a 6-2 majority, I argued to 8, Justice Scalia passed away before I argued, and Justice Gorsuch had not yet been confirmed. He wrote, and I quote him, "When a jury hears expert testimony that expressly makes a defendant's race directly pertinent on the question of life or death, the impact of that evidence cannot be measured simply by how much airtime it received at trial or how many pages it occupies in the record. Some toxins can be deadly in small doses." He also wrote, and I quote him, "Our law punishes people for what they do, not who they are. Dispensing punishment on the basis of an immutable characteristic flatly contravenes this guiding principle." So That's obviously good news. No, obviously, neither the Dwayne Buck case nor the Pine Bluff case were about innocence. And I run the Innocence Project. So, the reality is the statistics on race and wrongful convictions are pretty shocking. The National Registry of Exonerations conducted a study of all the exonerations since 1989, and what they found was that Black people were 7 times more likely than white people to be falsely convicted of serious crimes. Innocent Black people were nearly 8 times more likely than innocent white people to be falsely convicted of rape. Innocent Black people were 19 times more likely to be convicted of drug crimes, 19 times more likely to be convicted of drug crimes than innocent white people, even though there's no meaningful disparity in the rate at which Black people or white people use or possess drugs. And that the exonerations of innocent Black people convicted of murder were almost 50% more likely to include misconduct by police officers than the exonerations of white people who are convicted, than white people convicted of murder. So let's talk about what this looks like in practice in terms of an innocence case. I'm going to tell you about Calvin Johnson, who recently passed away. He was a Black man who, in the 1980s, was tried for 2 sexual assaults in 2 different counties in Georgia. The victims, both of whom were white women, described a clean-shaven Black man as their attacker. One of the victims identified Mr. Johnson's photo in a photo array, but did not select him in a lineup. The other did not pick Mr. Johnson's photo, but did identify him in a lineup. He first went on trial in Clayton County. Mr. Johnson and his attorney were the only Black people in the courtroom. The judge, the prosecutor, the clerk, the jury foreman, the stenographer, and the entire jury were white. 2 prospective Black jurors were stricken from the jury without explanation. And Mr. Johnson's fiancée mother, father, and his fiancée's mother all testified that Mr. Johnson had been with them on the day of the assault. But the all-white jury deliberated for 45 minutes before returning a guilty verdict. He was sentenced to life in prison. 7 months later, Mr. Johnson went on trial in Fulton County. He was offered a plea deal for the Fulton County case, but he rejected it. That second case was obviously much stronger because of the conviction in Clayton County, but he was tried before a diverse jury. It was comprised of 5 white people and 7 Black people, and that jury acquitted Calvin Johnson. 16 years later, the Innocence Project, using DNA testing, proved Mr. Johnson's innocence. He went on to be the first exonerated person to serve on the board of the Innocence Project. So the Pine Bluff case, the Dwayne Buck case, the Calvin Johnson case, each demonstrate sort of the roots of racial inequality and how they affect the contemporary functioning of the criminal legal system. They do, in fact, show that the past is never dead. It's not even past. So what does that mean for us, right? Are we stuck with this legacy of racism, or can it be interrupted? As it turns out, in each of the cases I discussed, individuals stepped forward and sort of prevented an injustice. They recognized, quoting Amanda Gorman, "There is always light if only we are brave enough to see it, and if only we are brave enough to be it." So these cases also offer important lessons about the unexpected ways in which lawyers and lay people can and do step up and in to promote justice, notwithstanding that history. So in the Pine Bluff case, obviously, it was that first Black prosecutor who testified in the evidentiary hearing for our case. You have to remember that Pine Bluff is this tiny place in Arkansas, right? And we were a bunch of carpet-bagging New York lawyers in town representing a man who had been convicted of murder in town. We were not fan favorites. And so when we went to visit him and he shared the story, we immediately said, "We want you to testify." And he really had to spend time thinking about the consequence to him, to his law practice, to his career, to his life in this community, and what it would mean for him to take the witness stand and share the testimony that he did. The night before he was scheduled to testify, we had actually no idea whether or not he was going to take the stand. As the morning broke and we went into the court and he was the next witness to be called, I can remember standing there wondering whether he was going to walk down the middle of the court hall, right, to take the witness stand. But he did. I can say that also, as he was walking down, he was sort of talking to himself, and then at some point he just said, F it. And, and off he went, and he took the witness stand, and he offered the testimony that I read to you. It obviously had a profound effect on the case in many ways. I will give you the easy reason, is that ultimately not only was our client's death sentence vacated, the court is currently, right, considering a fair cross-section challenge, right, wondering whether or not the juries that were drawn at the time of his trial were fair and constitutional. But more than that, more specifically, two other things happened. After he stepped off the witness stand, the court sort of broke for, we had a break in testimony. And then the judge came out and said for the first time after 5 days of testimony that he suddenly remembered that he was very close with the victim's family and promptly recused himself from the case, making clear he was not prepared to preside over this testimony. The other thing that happened was, again, not fan favorites. We represent a guy that killed someone in the town. So people weren't really talking to us. We were just coming in, doing our job. But as the testimony was presented, we drew a crowd, right? People started coming into the courtroom and listening to the testimony, and particularly listening to Mr. McKissick, that was his name, Mr. McKissick's testimony. After he came off the stand, we were swarmed, right? The defense table was swarmed by people in the courtroom. The two gentlemen who would drive our client and his co-defendant back and forth from prison, the gentleman who was the elderly black court clerk to the judge. All kinds of people came over, and they thanked us for introducing and calling Mr. McKissick to the stand and to have him share the history of what it is like in Pine Bluff, and they made clear that it was still that way at the time of the hearing. So it had enormous effect. And so he, of course, had no obligation to our case, right? He had no relation to our client. He had no relation to us. But in the interests, right, of justice in this case and knowing the impact, right, that the truth should and did have, he stepped up, right? So he was the light for us in that case. In the Dwayne Buck case, right, the case I argued in the Supreme Court, there were similar people who just simply stepped forward out of the goodness of their own hearts, out of a belief in justice. Mr. Buck's case was going on for years. I represented him for about 6 years. Ultimately, we got the phone call that we all dreaded before we got to the Supreme Court saying that the Harris County District Attorney's Office was going to go and request what they call a date-setting hearing, right? They were going to set an execution date for Mr. Buck. So we were scrambling to prevent that from happening. I used all the LDF razzmatazz that we had. Nothing was going to divert. This was a hard-charging, recently elected prosecutor, and he was ready to, put this very noisy case to bed. And so, I was frantically making phone calls, and I wound up on the phone with an 80-year-old gentleman who was a prior president of the local NAACP, an insurance salesman. And so I said, listen, I'm just trying to, the DA won't meet with us. I can't stop him from he can't have an execution date. I should be clear, we didn't have a well-formed plan for an appeal at this time. So if that execution date had been set, I knew we were going to be in trouble. So the gentleman, Mr. Howard Jefferson, said, listen to my rambling appeal. I said, I'll call you back. He did call back, and he said, all right, be in the DA's office at 7:30 a.m. the day of the date-setting hearing. I said, no problem, we'll be there. And there we were at 7:30 a.m. on the day of the date-setting hearing. He was there with Pastor William Lawson of the Wheeler Avenue Baptist Church, Archbishop Joseph Fiorenza of the Catholic Church, and Rabbi Samuel Karff. These men were 85 and up to a person. And so there we met them. We said, great, super. We'll just go all in there together and we'll explain all the reasons why this execution date should not be set. The elected prosecutor came out. He graciously greeted our friends. He ushered them into his office, and he told us to have a seat in the hallway. And so we did. And I was like, I don't know what is happening. Because as it turns out, these gentlemen know nothing about this case, except what I said, this race, is going to be sentenced to death, he's going to be executed because of his race. So we were there for about 2 hours. So the DA had called all of the victims' families to be in the courtroom for this date setting hearing. So there's about 30 people upstairs, and the judge, and all of counsel is now locked downstairs in this bizarre negotiation. So we missed the call of the case. The judge is calling downstairs, trying to understand what's going on. And at some point, the DA comes out and says, "You come in," so I get to go in. And he says, "Tell me about your appeal." So I explain what my appeal is going to be, and then he threw me back out. And so they're in there, we have no earthly idea what's going on. And what happens is that it's maybe 9:30, 10 o'clock at this point, and he comes back out, he ushers all of us in, and he said, the elected DA of Harris County, based solely, and I do mean solely, on the moral appeal presented by your four friends, I'm going to withdraw my application for an execution date. I don't believe your appeal has any merit. I am confident that once you file it, you will lose. And once you lose, I will set a date. But because of the moral appeal presented by Pastor Lawson, Howard Jefferson, Joseph Fiorenza, and Samuel Karff, I'm going to go upstairs and I'm going to walk this thing back. And he did. And it's only because of that we ever got to the United States Supreme Court. Had it not been for the intervention of these four gentlemen who, again, I did not know them. They did not know our client. They did not have a relationship with the Legal Defense Fund. If it had not been for their intervention that day, right, Mr. Buck would have been executed way before, 2017 when his case was announced. So we dubbed them the Godfathers, and they stayed with us for the legacy of the case. We made no decisions without them. They were sort of our guiding lights, right, through our time in Texas. They wrote a op-ed supporting our case, and I'll just read a portion of what they said. They said, and I quote, "Mr. Buck's case is ultimately about his life and his humanity, as it is about the life and humanity of each member of our community who allows or refuses to allow the injustice in his case to go unchecked. Thus, to save Mr. Buck and to save ourselves, we must speak out with boldness and urgency as God did when he answered the prophet Habakkuk's prayer for justice. I must stand up, speak up, and do what's right, and call for a new, fair sentencing for Mr. Buck." They were extraordinary. They are, just nothing but light. And because of them, right, and because of their actions, right, sort of light attracts light, we had more supporters. Second chair counsel for the state in the prosecution of Mr. Buck emerged and said, "I want to see the transcript because I'm hearing about this case." Her name is Linda Geffen. She prosecuted it. She was second counsel prosecutor. We sent her the transcript. She read it. She was horrified. And she said, "I am not going to support this execution." I just want to be clear. She was a sitting prosecutor. She was a county prosecutor. She was doing sex trafficking cases. And for the first time in her career, she stood up and she spoke out against one of her own cases. And she was with us in the United States Supreme Court the day that case was argued. Phyllis Taylor was the half-sister of Dwayne Buck. She was actually shot. He shot her. Mr. Buck shot her in the chest on the evening of the crime. As you might imagine, they did not stay in contact after she got shot. But once she too heard about the case, she reached out. She said, "I want to talk to my brother." And we said, "Okay, no problem." And she met with her brother, and she came out and she said, "Nope, I'm not going to support this." And so it is, we went to the Supreme Court with the Godfathers, with Linda Geffen, right, second chair prosecutor for the state of Texas against Dwayne Edward Buck, and a surviving victim, right? These are the true heroes, right? And they're a reminder, right? I get a lot of credit for Dwayne Buck and for these other cases, but you don't have to be a litigator, you don't have to be a Supreme Court litigator to have a profound impact on justice, to interrupt, right, the history of this country. You just have to be willing to run in and toward justice when everyone else is running away. In Calvin Johnson's case, it is, of course, my extraordinary colleagues at the Innocence Project, right? I like to say without shame that the Innocence Project is the most transformative criminal legal system reform organization in American history. In the last 30 years, we have freed or exonerated more than 240 people, 57% of whom are Black. As an organization, we are committed to addressing the ways in which racial bias undermines the integrity of the criminal legal system and drives wrongful convictions. because 2/3 of all DNA exonerations involve mistaken identification, including, of course, cross-racial identification. Our work drove the research that documented the phenomenon of own race bias, right? The fact that all of us are best able to recognize people of our own race, right? And that research drove the police practice reforms to promote accurate identification procedures. It drove the laws to allow experts to testify about the fallibility of eyewitness identification. Looking forward, of course, we are watching unreliable and unvalidated surveillance and investigative technologies like ShotSpotter, predictive policing, facial recognition software that undermine the presumption of innocence, particularly in over-policed communities of color. We are documenting, investigating, and preparing to challenge those kinds of practices. We are acutely aware as an organization and a community that we need to acknowledge and grapple with our nation's history in order to move our work forward and to fulfill our mission as an organization to free the innocent, to prevent wrongful convictions, and to create fair, compassionate, and equitable systems of justice for everyone. And I thank you. We're taking questions.
Thank you. Yes.
That's a great question. So we have about 200 cases on our docket, and we have about, we're hiring. So once we're fully hired, I think we'll have about 15 lawyers in the post-conviction litigation team. That's the team that sort of works to exonerate and free people. And then we have another 4 lawyers who do strategic litigation, meaning, right, law reform, right? We want to train lawyers and prosecutors and judges and do amicus briefs, right, sort of change law in the courts. So, so I guess we'll have about 20 to 25 lawyers. But, the thing I think that's also extraordinary about the Innocence Project is that we don't end, right? We can't just try to free people, right? I like to think you got to turn off the faucet, right? If there's just a continual flow of wrongful convictions coming into the system, we can never keep up. So, we also have a policy team, right, who's dedicated to changing the laws to prevent, changing the laws to make sure that we understand that when we learn about how people are being wrongfully convicted, whether it's eyewitness identification, false confession, right, snitches and other ways, right, we change the laws so we reduce the likelihood of other people, right, experiencing the same thing. So we have an extraordinary policy team doing that. And, we also have an extraordinary team of social workers because we're, dedicated to seeing our clients succeed once they are freed and at home, right? Our clients have spent decades and decades in prison, so they experience extraordinary trauma and difficulties. And so we try very hard to smooth the reintegration and make sure that they have the opportunity, to return to life, to the community as fully and as holistically as we can. No, please, keep going. We are funded, we don't take, my organization does not take government money, so it's funded by a mix of mostly individual contributions, but also some foundations.
And when you look to change laws, do you limit yourself to Pennsylvania? Do you go federally?
So I'm going to shout out my colleagues in the audience. The Pennsylvania Innocence Project is sitting right behind you. So yes. And the New Jersey Innocence Project is also sitting right behind you. Welcome to the party, New Jersey, brand new to the fold. And so the New York Innocence Project, which is where I work, right, we work, we're sort of national. We try to work in states where we do not have, robustly, staffed and funded organizations, or in states, like Texas, where there's just so much, and in New York, right, where there's so much injustice, where you still need us. So we work all over the country, but, Pennsylvania has an extraordinary Innocence Project here.
Sir, hi. How you doing? Is your policy team working to deal with those jurisdictions attempting for priests to testify on confessions that happen in the confession booth?
We have not, I have to say that my office so far has not represented one of the Catholic Church cases. We just haven't. So is it impossible? No, we just haven't. So that's not an issue that we have worked on. I think there was a question here.
They convicted him to death because they thought he was a danger.
Mm-hmm.
How dangerous could he be if he was in prison?
Such a good question. Thank you for that question. So, yes, well, the theory, I guess, if you ask the prosecutor, would be that he might be a danger to someone in prison, right? So if he was serving a life sentence, he could kill someone in prison. However, as Justice Roberts wrote, what they actually presented at the sentencing hearing was that he had one, because he had no, all right, this is a funny story. He had 2 prior convictions, Mr. Buck. One was for drugs, so that was meaningless for this question. And the second was for possession of a weapon, which for months roiled me. I was like, why, isn't that a violent felony conviction? And then they were like, no, this is Texas. It's totally true story. They're like, not in Texas. I was like, oh. In New York, that would be a very big problem, not in Texas. So none of his convictions qualified, right, but what they brought in was he had a prior girlfriend who he had a difficult relationship. So there was some evidence of domestic violence. So the theory was, right, oh, well, he had this prior domestic violence incident, so here's the evidence of, to the extent they had any, here's the evidence of, violence in addition to race. Justice Roberts, however, writes, and as we argued, right, even if you accept that to be true, right, you accept that this incident occurred, the killing that occurred was a domestic violence incident, and he had a prior, the likelihood of him having a relationship with a woman in prison was 0. And so, right, that there wasn't that kind of formula that if you were going to assume there was a formula for Dwayne Buck, it wouldn't exist in a life sentence situation. And so Justice Roberts acknowledged, right, that's the finding he makes, right? No, there isn't the likelihood under the circumstances here. We always said, of course, as well, by the time we got to the Supreme Court, he had been on death row for 20 some odd years. We're like, whatever you may have thought, it has already been disproven, right? He had had no infractions. I think his only infraction during the entire time that he was in prison was he had possession of stamps that he wasn't supposed to have, right? There was no evidence, right? There were, prison officials who I think would have testified in his behalf were we required to go to another penalty phase. He was a model prisoner. So whatever prediction, the business of predicting future dangerousness, of course, is ridiculous, but whatever prediction was made, right, was proven to be false.
Any of the students have a question you'd love to pose?
How do you decide which cases to take and which cases not to take? I imagine you're flooded
Oh my, yes.
with tons and tons of cases.
Yes, we do. We don't like to use the word backlog, but we do have a lot of cases in the queue waiting. So we have also an extraordinary intake department. So we have about 15 people whose job is exclusively sort of to receive and review all of the requests for representation that we receive. My office primarily focuses on DNA exonerations. That's the history of this organization. We have sort of been a DNA-focused place. So if someone writes to us, right, just sort of a simple screen, air quotes simple, right? Do you say you're innocent? Yes, right? Is this a case that involves biological evidence that could be tested? Yes. Then is the biological evidence available and can it be tested, right? So a lot of cases, as my colleagues will attest, right, there's so many times over and over again that we have people who, convicted of rape, but the biological evidence has been destroyed, degraded, lost, all kinds of things. So even if they do claim they're innocent and could be exonerated by DNA, testing, we can't because we can't get our hands on the evidence to test it. So that's generally the screen. So we have this amazing group who, reaches out and gets all the transcripts, gets all the police reports, gets all the prior testing, if any testing has been done, the forensic reports. They're, extremely well educated in terms of knowledge of when, where, and how you can or cannot get DNA from what kinds of, substances and, surfaces. And so they do a really comprehensive analysis of every single case that comes in, and then they make a recommendation to the post-conviction litigation team. And so that's kind of the process. We are going forward, we also take some faulty forensics cases, right? Cases that we know are based on sort of air quotes, junk science, right? Things that we know are not real science, and we've been litigating those. And going forward, I think we're going to open and expand the bases on which we take cases beyond just DNA to sort of non-DNA cases as well. But we haven't gotten there yet.
Outside of like DNA testing, what are like other experts that you utilize like in your work or in your cases, and how do you select them? Considering the horror story you have.
Bad expert, yeah, that's right. That was a bad expert story. So many things, right? So our cases, you never know what's going to happen. So sometimes you'll have a DNA case, for whatever reason you can't get a result, but, right, maybe there's also indications that there was a false confession, right? So a false confession expert would come in. Sometimes you would also have indications that there was an erroneous identification. So you get an ID expert to come in. So there are all kinds of additional experts that we use, right, to sort of bolster or to support, right, DNA. Because often, right, we're also in a fight, right, over what it means, whether it's exonerating, whether it proves innocence or not. So we try very hard to sort of present a complete case, right, of innocence. So choosing the expert, right, it's really important, choosing your experts. You have to do research, see prior testimony that they've given, right, make sure that their history, that, they've been qualified when they've been called, that they haven't offered crazy testimony like this expert, right? You talk to our colleagues, right, across the country. We sort of have a nice network where we communicate to each other about, experts that have been successful in our cases and experts that haven't been so successful in our cases. So sort of that's the route.
So we have time for 2 more questions. I'll see if we can squeeze. Let's go.
To what extent do you find that state and local prosecutors' offices are now doing innocence and lawful conviction work, and do you work with those offices? Logically, you would.
Yeah. Look, the good news story, I think, is, right, from when we all started, back when the dinosaurs roamed the earth, right, prosecutors' offices wouldn't even fathom, right, a world where you would have, prosecutors reinvestigating cases with an eye toward, their own cases with an eye toward innocence, right? So this is a watershed development, right, in sort of the arc of the legal system in our country, that we now have prosecutor offices across the country dedicating units, right, dedicating time, resources, and assistant DAs, right, to units to reinvestigate these cases. So of course, I think, all of us, we bring a case to the DA's office. I will not say we're not made equal, right? Some of those units are better than others. Some of those offices are better than others. And so, what it means that an office has one is, right, there's some reason for hope, but it really is, of course, right, the devil's in the details. What are they doing with that, right? You have to actually make that unit, you have to, right, empower it. You need to be, ready to do sort of collaborative reinvestigations with the defense, right? There are real best practices that have been developed by our colleagues at the Quattrone Center and across the country around sort of collaborations between innocence projects and those units. And so we want to see those offices really engaging in sort of the best practices and not just slapping a label on, a group of appellate prosecutors and saying, we're now doing this, right? It really does require a change in perspective and a change in approach. But I welcome, right, the introduction of these units is really important.
So I am sorry, but we've gone way over time. But before we do our final thank you, I'd like to share 2 other things. One is, we're very Temple proud because the Pennsylvania Innocence Project was sort of given a home, you could say that the right way, and given its first boost by Temple Law School. And we're really honored to have that. Yes, and they're located at Temple University Center City. The other thing is, just talking about the project, our friend Chris Fabricant, all right, we want to find some really interesting reading to follow up on what we heard today. Chris Fabricant, who's done more special litigation, I don't know what else to call it, challenging junk science, including here in Pennsylvania, challenging bite mark evidence, which is still being used in Pennsylvania, wrote a marvelous book this last year called Junk Science. And it's a you don't have to have any scientific background, but you want to learn another angle of the many angles of what innocence projects do and what has been so wrong in the criminal prosecution system. Get yourself a copy of Junk Science. It is worth the read. But with that, will you join me in thanking our speaker?